today we're going to talk about some of the major impacts that have stemmed from the recent decision involving Coles and Woolies. It's probably Australia's largest underpayment claim. I'll talk you through the situation of how it's arisen, what the court has determined, and it's quite important because the court's taken quite a different approach, and it's one that may well impact a lot of award employees, particularly employees who engage managers, or they've got lower level managers who actually are award covered. So we'll go through that, and we'll also look at what that impact means and what we can do about to sort of mitigate risks moving forward. But at the moment, it's a fairly major change in the way we draft our employment contracts, and also what the approach employers need to take with respect to annual salaries. So what we've found here, and I'll talk you through what the key compliance areas that we need to discuss today is, but the federal court rulings against Coles and Woolworths essentially mandate a fundamental shift in relation to Australian payroll compliance. And we're going to cover today the impact of the court's decision on set-off clauses, and particularly the difference now that exists quite strongly between set-off clauses and annual wage arrangements. We're going to talk about the pay period rule that's been implemented by the court. There's a clear decision by the court now where overpayments, future or previous, cannot offset later or previous shortfalls. What the set-off clause is allowing you to do is to set off overpayments against extra work performed in a particular pay period, but not necessarily use deficiencies from previous months against extra time in later months. I'm going to talk to you about payroll and contract red flags that have arisen as a result of the decision, the mandatory record keeping, and also some of the impacts that this decision has created as a result of it, because the court was quite damning on both Woolworths and Coles in relation to their record keeping and what that actually meant for determining the underpayments. And we're going to talk about taking some practical steps and some future steps for some future proofing moving forward. So the Woolworths and Coles decision relate to legal action centred around underpayment claims involving thousands of salaried store managers covered by modern awards and classifications in the general retail industry. The claims were that their fixed annual salaries failed to compensate these senior or these salaried store managers for their mandatory award entitlements, primarily their penalty rates, overtime and allowances. Now, Justice Perham came to a conclusion that there were systemic failures by both Woolworths and Coles, pointing to ongoing deficiencies in compliance and governance, and not just simple calculations or errors. And the legal recovery that Coles and Woolly are now exposed to are quite dramatic. The possible remediation that Woolworths is facing as a result of the findings of the court are in excess of 300 million, and Coles at 7 million. This decision is actually affecting all employers who are used annualised salaries or set-off clauses for award-covered staff. So it's fairly dramatic. The major impact is obviously for employment contracts for people who with an annualised salary relying solely on a set-off clause. Sorry, I've gone too far. So the key change that has occurred is that the pay period now is the sole unit of compliance. Sorry, what's just happened there? Thanks, EJ. So what the court found is that it examined the wording of Section 323 of the Fair Work Act, and it placed an incredible amount of weight upon what that section says. That section says that monetary entitlements must be paid in full for each prescribed pay period. And that includes all entitlements, including minimum hourly rates, penalty rates, and specific allowances. By placing a particular weight in saying it in full and for each prescribed period, it wasn't talking about the averaging period contained in an award. It was talking about the required pay period. So if an award requires people to be paid weekly, fortnightly, or monthly, that will be the prescribed pay period that will be used to determine whether or not the person has been paid in full. So if they've worked overtime or have allowances or penalty rates, it's that period that we're examining. So say, and what the court declined to do and said was not appropriate because of the wording of section 323 was to allow averaging over a longer or more extended period, or to allow set-offs from periods where someone's perhaps been overpaid or had a buffer to be utilised against underpayments, which would accrue in one particular period. So say at Christmas, where parties have been working long hours in the retail industry, the underpayments or the buffer that existed for the 11 months previously can't be used to set off against the overpayments or the underpayment that occurred at Christmas. So in that particular sense, it said each pay period is a distinct unit of compliance. And in that case, if we've overpaid or we've provided a buffer there, the buffer for that month can be used, but not previous buffers. It also said that, the previous buffers can't be used against future underpayments and the other way around as well. So that future buffers can't be used to offset against previous underpayments. So what it's strictly saying is that if you have an annualised salary, your salary for that month needs to cover them for all the work that they've performed in that month, and that the buffers for the other periods or the other fortnights or months can't be used in the calculation to offset it. That's a fairly dramatic change, particularly when you've got averaging clauses in awards saying, hey, this is how we're going to average hours of work over extended periods of time, because that averaging clause doesn't really seem to have much impact if we're looking to say, well, we've got to make sure we've met their minimum award entitlements in each distinct month. And it's particularly more relevant too, where someone's, achieving an annualised salary for the purpose of spreading that out, the hours for the year over the year. So that process where we've used or relied upon a common law set-off clause in the past to allow for the give and take that was previously there is no longer allowed. And it's very clear to the courts that the courts have said, no, that's not an acceptable use. There is a distinction though, and both Coles and Woolies had their salaried store managers on annual salaries, but only with common law set-off clauses. And the court said, whilst for those set-off clauses, they'll only apply for the month, but the court's gone into quite a bit of detail to say if they were on annualised wage agreements, which are also specified under the modern awards, those an annualised wage agreement would be able to be calculated over the year as long as all the requirements and the strict accounting responsibilities that go along with an annualised wage agreement are met. So there's a distinct difference now between a employment contract that has a equitable set-off clause. You'll be limited to the month or the pay period that you pay in, compared to having an employment contract which is an annualised wage agreement, which is strictly been written in accordance with the award and complies with the award. You will be able to do a wider period of averaging under the annualised wage agreement, but you won't be able to do that extended averaging under an equitable set-off clause. So it's quite a dramatic difference, where in the past, a lot of employers have said, well, why would I go to the extent of doing the annualised wage agreement when I used to be able to simply have the equitable set-off clause to achieve close to or similar same effect. Can I go to the next slide, please? So we're essentially repeating here, but this is what the court said. The previous widespread practice relied on pooling excess salary paid during quiet weeks to compensate for shortfalls incurred during busiest weeks will no longer be allowed. And Woolworths set-off clause attempted to satisfy entitlements over a 26-week period, and that also was rejected. He said the best you could do would be the month, which is the month in which they paid the monthly salaries. The federal court was very clear. It's been known as the Perham test. They're saying contractual set-off can only discharge obligations that accrue within a single pay period. The use of overpayments in earlier cycles to remedy a shortfall in a later cycle is not permissible under the Fair Work Act. If a shortfall occurs in any given fortnight or pay period, the previous overpayment from previous pay periods cannot be legally utilised to remedy that underpayment in the following or later pay periods. So essentially the offset clause has been restricted greatly, and it will be of limited use unless there's quite a substantial buffer. Can I go to the next slide, please? If you actually have a look at the judgment, and I would encourage you to do so, it's 494 pages, don't fret at that. Go to paragraph 40 and read through to paragraph 80. That talks about the major aspects of the impact on equitable set-offs. And you can see he goes through quite a great deal of depth to justify his conclusion. But essentially, he said that the approach that the equitable set-off clause that's been contained in nearly all sort of common law employment contracts for managers is it amounts to an accounting abstraction. He said the reliance, sorry, just go back. Can I grab control, EJ, or? No. He essentially said that it's an accounting abstraction, that the methodology that we've used is not authorised by Section 323 of the Fair Work Act. That section is explicit in requiring full payment for all penalties and loadings in each pay period, and that you can't then go and do an accounting exercise because the Section 323 explicitly requires a full payment for all the hours worked in that period, and that to do otherwise essentially is an accounting abstraction that's not authorised by the Fair Work Act. The implication of that very simple statement is that it invalidates most legacy contracts relied upon which require a multi-period reconciliation for award-covered employees. And now periods of peak activity or high penalty work become high risk pay cycles that must meet compliance in that month. So in the past where we've said, look, I've sat down and I worked out the hours they're going to work in the year. Here's what the buffer is, and this is the amount of additional hours that's compensated for in my buffer. That will be of little effect because it'll only be whether or not the monthly buffer is enough to compensate them for the work that's been performed in that peak pay period. So even though we may not have underpaid for the 11th previous months, we might actually have perhaps even overpaid because we've set the buffer to include these peak periods. It's that 1 month where the underpayment possibly could arise, or in this particular case it could be a range of different periods. It could be Christmas, it could be Easter, it could be just periods where we have been working extra time, stock take periods, shortfall of someone goes on leave and they're working additional hours to cover those periods of leave. All those sorts of situations need to be assessed now on a monthly basis to ensure that that monthly pay packet is enough to cover them for that period. Can I jump to the next one, please, EJ? So the key difference here is that the common law clause, where a higher salary is paid to absorb those entitlements, is going to be limited in its utility. A contractual set-off will only be lawful if the salary paid in a specific pay period is sufficient to cover the total award entitlements accrued in the same period, and it must be restricted to the current pay cycle. That's never been expressly stated before. Now it's somewhat uncontrovertible based upon this current decision. I will talk to you at the moment, though, that at the moment this decision has not been appealed by Woolworths, who's the most affected party. They've said that they will consider appealing it after they've had a full time to consider it. It's only 6 weeks, 8 weeks old now at the moment. So they've still got plenty of time to consider whether they want to appeal it. And this was actually an interim finding. So it was a preliminary finding, and now they're going through to work out, well, how much will the exposure actually be and what the remediation process is. You can expect, given the gravity, particularly for Woolworths, sitting at 300 million, that they probably will appeal. Whether the appeal is successful or not, though, remains to be seen. But at the moment, the court has come down fairly hard and said, look, this is the approach that they expect employers to take moving forward. Can I just jump to the next slide, please, EJ? So essentially, if we were to comply with or to change our current contracts, employment contracts, and we were going to maintain the common law set-off clause, we would need to make some change to the sort of the standard wording. I've put here an example of a clause or an amended clause for an equitable set-off clause, but it will not remedy the fact that the court has said we can't go and use previous or future months to offset the extra hours. So to reflect what the court is saying, the best we can now do with a common law set-off clause would be something like as follows. And you'll see here it's the first line. It's changed. Most of it hasn't changed otherwise. Your remuneration benefits are in satisfaction of and compensate you in full for each pay or roster period for all aspects of work performed by you at any time and under any condition, and for all of these following specific entitlements. Now, the court was also very clear that you need to clearly indicate in your set-off clause what entitlements that you are including in your buffer. So just simply saying any and all entitlements is probably not enough anymore. We probably need to go through and outline. So I've given an example there of how we could do that. But you see there, we've tried to do it broadly, but also have the specific, like the particular aspects of which penalties and loadings and allowances are included in there. But the key change is that first line, and it's now limiting it to compensation in full for each pay or roster period. In that particular case, the court says, okay, well that may well cover you because you're complying with what we've said, but it also limits you because you can't then go and use the previous buffers against future possible underpayment periods. So it really, whilst that changes there, and that's reflecting what the court says, I would highlight to you, it really is limiting now the utility of the equitable set-off clause for award-covered salaried managers or award-covered annualised salary employees. But that would be the sort of change that I suggest you might need to consider if you wanted to continue to rely upon that. Can I just flick to the next slide, please, EJ? Now, the key distinction here is, and the court has made in the judgment, is that while a contractual set-off cannot pool entitlements across a period, annualised wage agreements and the framework that exists within the modern awards will permit average entitlements over a year, provided the stringent conditions that accompany the annualised wage agreements are met. So what if you want to continue to safely use annualised salaries for say senior managers or someone like that situation, or even your basic employees, and you want to sort of spread the cost or have an even amount over the year without the risk of having periods of underpayments, you might want to give careful consideration as to whether your modern award allows you to have an annualised wage agreement. And if so, you might want to convert your current annualised salary staff to such an agreement. Now, there are some stringent requirements that accompany the annualised wage agreements. That means that we need to do a yearly accounting to ensure that they're not receiving less than what they would have received under the award. And we also need to do that same exercise once they finish their employment. So there's a lot more payroll compliance that sort of sits with an annualised wage arrangement, but it does still retain the benefits that used to be allowed through using the contractual or equitable set-off clause previously. So it's one to give a great deal of thought to, is whether or not you continue to move forward with the contractual set-off clause. And if you do, how are you then going to ensure that you're paying the correct amount during periods of high risk work, and also being mindful that you can only limit the set off to that pay period, like the fortnight in which they were paid or the month in which they were paid, or whether you may now then say, okay, well, let's convert or move across to AWAs or the annualised wage agreements. But if we do move to annualised wage agreements, how are you then going to ensure that you meet the higher payroll compliance that then attaches to that, to make sure that you're doing your yearly audit to ensure that they're meeting the requirements? And there are also some quite clear differences in how that's specified. So the annualised wage agreement needs to be in writing. It needs to specify how it was calculated as well, what is included, what hours were included, and how you arrived at your figure. So it's a lot more involved than what used to be involved in just simply saying, hey, I'm going to provide you an annualised salary and then have the set-off clause. You will need to justify how you arrived at those figures. But the advantage of it is that it does allow you to continue to pay over that 12-month period and to spread the costs and also mitigate the risk where the risks have just exponentially increased, in my view, through the Coles and Woolies decision as it currently stands. Can I flip to the next one, please, EJ? So I've put in here what are the two strict legal protections for annualised wage agreements. The first one's the safety net principle. You must guarantee they won't receive less than they would have over the course of the year for the hours that they worked for all their award entitlements. And the award may also specify a maximum number of penalty or overtime hours intended to be covered. Work beyond this threshold must also be paid in addition to the annual salary. It's a bit of a catch-all for the AWAs. And again, there will be that increased cost of the mandatory reconciliation, which is an award requirement for the annualised wage agreement to be effective, is that we must do a formal reconciliation every 12 months or upon the cessation. And if you identify an underpayment, you obviously need to rectify it. Can I flick to the next one, please, EJ? So identifying underpayment risks for annualised salaries, what are the major red flags? Well, if we continue on down the path with, and we don't move to, say, annualised wage agreements, and we have that sort of equitable offset, the real risk for us is where we've got fluctuating overtime and penalty hours. So salaried award covered staff whose schedules require substantial or fluctuating hours, such as weekend work, public holiday work, or regular overtime, are now at high risk of being underpaid for those periods. It might be worth sitting down in that case to say, okay, what is the risk? How much will we be up for? And perhaps use periods where they work some weekends or they work public holidays, what will that actually mean to our hip pocket, and how much will we be underpaying now that we can't offset over the 11 months or the other 11 months? It really is only going to affect people below the high income threshold. So it's only going to affect award covered employees earning below the high income threshold, who require mandatory and detailed time and wages records. But for a lot of us, that's a lot of our staff. Misinterpretation of awards. So failure to incorporate the latest award conditions or use incorrect classifications or neglect mandated allowances are another real risk. So in the past, where people have relied upon the buffer to say, look, those allowances are minor and I've got such a buffer over the year that it's not really going to impact me, now create actually a very real risk for you, because your buffer can't extend over 12 months. It can only extend to, say, the pay period. So if you're paying monthly, you need to, and the buffer is being eaten up by an increase in overtime, you need to also pay close attention to some of those other things in the past which your payroll team may not have given as much weight to, such as additional allowances, travel time, those sorts of aspects may actually kick you over into a situation where you're now underpaying. And the last one will be reliance on legacy contracts. So, employees may well be engaged in contracts from 2, 3, 4 years, even last year. They're not going to perhaps have a compliant offset clause. And if payroll aren't made aware of these changes, or we haven't got a system for monitoring what's going on, you're likely to be exposing yourself to a situation where in the next year or so, someone pops up and says, hey, I've been underpaid, or the union come in and knock on the door and say, hey, you haven't taken into account the impact of this Woolworths and Coles decision. So it's probably now is the time to sit down and say, okay, what's the impact upon me, and do I need to move? Do I need to update my contracts and then reassess whether I need to pay extra in these peak periods, or do I consider moving my salaried staff across to those annualised wage agreements? The court was also quite damning on Coles and Woolies that their record keeping was inadequate for them to be able to safely determine what hours had worked. Coles and Woolies were relying quite strongly on check-in, check-out times and times recorded in rosters, but also, on finish times on those rosters. They're saying that's not good enough. There needs to be strict record keeping put in place. What time you started, what time you took your breaks, what time you came back from your breaks, and what time you finished, and how much overtime you actually did each day. And just relying upon a roster or relying upon a say-so type entry, I did 3 hours overtime, is not good enough. There actually needs to be strict time keeping and time records. And there will also, you'll see with the annualised wage agreements too, there needs to be sort of some strict compliance on people recording their hours and agreeing that those hours are the hours that they worked. This is a fairly dramatic change. For a lot of time, people would say, okay, well, here's your rostered hours, and also, you're only to work the overtime that we've allocated to you. There may be situations where the court said there may be situations, though, where, say, someone doesn't come back from the shift and the person's required to work extra and it's not properly recorded where it should have been. So, or they've had to stay back and, someone's gone home sick and they've worked extra hours and there's no real record of when their final working hours were. And they're saying that's not meeting the strict timekeeping requirements as required by the award. So they're really actually putting the onus quite strongly on employers to almost have to do pencil and paper type time recording or quite a lot of data entry to have accurate figures. But they're saying it should be accurate and it's, you know, and the safer option is too is that both the employer and the employee have agreed that they're the hours or the times that they worked. But simply relying upon rosters or relying upon that the additional hours weren't approved will not be a defence if there's been a legitimate requirement or a legitimate reason that the employee actually had to work the extra hours. And if you consider that on top of the fact that the set-off clause now is only limited to that pay period, you can see that that can really blow out you know, the amount of underpayment in those peak periods as well. Yep. Again, the court was quite clear. They said it was legally insufficient if this information can only be deducted from raw clock-in data. So what they're saying here too is that raw clock-in data might not actually reflect the hours that someone's actually done. So if someone's actually had to stay back longer and they've clocked off in their shift, but there's been additional work and there's a, you know, a substantial amount of work that they've been required to do, you know, simply recording or relying upon a clock-in or a clock-out time or a rostered off time is not sufficient. The parties need to have accurate records, and you almost need to have their agreement that, yes, these are the hours that I worked. On top of that, you can't just estimate start and finish times either. It needs to be accurate. They're almost wanting to the basis, to the minute. So the consequences of record keeping failure: without accurate time records, the employer cannot conclusively demonstrate compliance with the pay period specific standard. And also the courts have indicated that this is going to cause, if you haven't got accurate time record keepings, you're going to have difficulty satisfying the reverse onus of proof. So if you fail to produce the mandated records when an underpayment claim is made without a reasonable excuse, then the issue is that they're going to say, well, we're not satisfied. You've satisfied the reverse onus of proof, and therefore they may well rely upon the fact that the records you say that they worked won't carry the weight, and they're likely to find that they've worked the more excessive hours being claimed by the employee. So that is a fairly dramatic change to a certain extent. They're saying, without a doubt now, if you haven't got accurate records and you don't have accurate payroll systems, you're going to place yourself at a disadvantage before the courts if someone brings an underpayment claim. Now, the difficulty we have here is that most of us are relying upon rostering systems or payroll systems that are automated. They don't. To change these systems or to put these, you know, down to a minute or extra hours is a lot of extra work. You're going to need to consider how you go about reconciling the rosters with the hours actually performed, and maybe it's about you know, doing it on a weekly or monthly basis to do a short reconciliation as you go. But to rely upon that data or to try and reconstruct that data, you know, going back 6 years in the event of an individual underpayment claim will be an incredibly difficult exercise if you haven't done it as you go. Can we flip to the next one, please, EJ? So I suppose the issue here comes down to is, well, how do we go about determining whether we've now underpaid based upon the Coles and Woolies decision? And it would be simply at the moment is to identify all award-covered salaried employees and then perhaps prioritise the high-risk roles or pay periods. So it could be if you've got award-covered managers, I would say to you that's fairly clear indicator that they're going to be a high-risk role, or people who are working on public holidays or peak activity periods. So if you have seasonal work or seasonal peaks, they're going to be your high-risk periods. You want to collect all the time data. That's not necessarily the rosters. As you can see, it's going to be the actual time worked for the 7-year retention period. So if you haven't got that data, it's a clear indicator that you're a little bit at risk, but also, okay, how to, I need to go and make sure that I've got that data moving forward. So, timekeeping records now, I suggest that it's just don't rely upon the roster or the check-in, check-out. You actually probably want people to actually record on a daily basis when they started, when they stopped, and when their breaks were. For the high-risk periods, you want to perhaps manually calculate the exact minimum award entitlements, including all penalties, loadings, and allowances. So it's probably worth sitting down and actually saying, okay, in this peak period, what should have I paid and what did I pay? And then compare the minimum award payment against the gross pay received in that period and work out whether or not there's likely to be an underpayment. And if there is an underpayment, you would then identify the shortfall and rectify it. Can I flick to the next one, please, EJ? So moving forward, practical step 2 is to update your contracts and systems. If you're going to continue to rely upon the contractual offset clause, review your current employment contracts. I did give you an example of the wording. It's not a major change to your wording, but you would need to change that wording. But if you change that wording, you then need to say, well, okay, what's the impact of that wording? So you actually need to do two things. You would need to change your contracts, but also identify, well, what is the risk, and perhaps do that payroll audit on the previous page. The other option is to sit down and say, if we want to continue doing what we've done in the past, and we know that the buffer is there except in these peak periods, but it would be covered over the 12-month totality, you may need to consider moving your contracts away from the contractual set-off to the annualised wage agreements. And again, I would suggest getting some legal advice as to what those new contracts should look like, and also some assistance to make sure you're strictly complying with the written requirements in relation to those annualised wage agreements. And then finally, the other aspect is to look at your system controls. So you're going to need to implement a continuous process that does a comparison between your salary instalments and accrued award entitlements. So it's about then saying, okay, how are we going to regularly audit what we've paid people against that, what they should have received in that pay period if we're relying on the common law set off, or how are we going to ensure that we're doing our 12-month wage reconciliation if we move to the new annualised wage agreement. That probably will mean that you need to do some further fail-safe checks with your software provider, or how are you going to identify who are the peak employees who are at risk of having an underpayment in those peak periods, and then what steps you're going to take to do the remedies to ensure that in those peak periods they're not being underpaid. But what you don't want to do is have a situation where this goes on for years and years, and you don't do the reconciliation and you don't do the audit, because then you end up in a situation like you've got with Woolies and Coles here, where you haven't done the checks, or you don't have the information to allow you to do the checks. If you have a large workforce, it quickly adds up. I'm not expecting us all to be in a situation of Woolies facing 300 million, but you can see how quickly it can spiral. So that's where monitoring regularly or having a system in place will minimise your risks moving forward. Demonstrating active compliance. So if you identify significant non-compliance, the most effective strategy for mitigating penalties is to follow the Fair Work Ombudsman's guidance on undertaking a proactive, self-initiated payroll remediation program. Self-correction demonstrates active compliance and will be considered a mitigated factor against severe penalties. If you are facing that situation, I would like you to pick up the phone and have a chat to me. We need to then perhaps consider, okay, well, what do we do? How do we do it? And get legal, get it subject to professional legal the advice subject to professional legal privilege. Legal professional privilege, sorry, I haven't had my coffee this morning, to get that over that, but also work out if it's a significant payment, well, how do we discharge that? Because quite often there could be a cash flow difficulty. How do we go and contact past employees who are no longer working for us? What sort of deeds do we need to have in place, and when do we notify the Ombudsman of our rectification program? I've spoken about that in previous sort of webinars, but if that's something that you're concerned about, it's not something I'm going to go into detail here, but I just would encourage you to pick up the phone and we go through what do we do when we're faced with a significant underpayment. But the key issue here is that we don't want to brush it necessarily under the carpet. We need to be taking positive steps to say, okay, well, I've identified it and now I'm going to rectify it. Can I jump to the next slide, please, EJ? So I know what I've probably told a lot of people is a bit shocking. But that's the way the law currently stands. The key here, though, is to say, okay, now I know what the law is, what do I do about it? So the issue here is that there's a lot of work to be done for payroll departments and HR departments. HR needs to identify what are we going to do moving forward and what is the actual risk to us? Do we simply modify our employment contract so we have a compliance set-off clause where we're limiting it to particular pay periods and being really specific as to what penalties are included, or should we move our staff to annualised wage agreements? Payroll need to go through and say, in a practical sense, how do I identify who's at risk? How do I do those payroll audits? What will be the factor that triggers it? And how do I ensure that I can identify and undertake compliance in a cost-effective manner moving forward? And also, if you then move to the annualised wage agreements, how my payroll will need to implement a suitable sort of reconciliation process at least once a year that's accurate, detailed, and justifiable. Payroll also will need to work quite closely with HR to identify, if you move to annualised wage agreements, how you arrived at your annual salary. So what hours were included, what were used, what allowances were included to arrive at that annualised salary figure. And then those additional hours then need to be calculated against over that 12-month reconciliation to make sure we haven't underpaid compared to what we said was in place for that annualised wage agreement. Can I just flick to the next one, please, EJ? So both of them have a little bit of a risk. I put here, what are the sort of the key features and what are the sort of the risks. So with the contractual set off, the basis of that existing common law or a contract, where the annualised wage arrangement is expressly regulated by a modern award as to what's required. The failure point for the contractual set-off, which I probably said to the cows come home today, is attempting to pool the entitlements across multiple pay periods will no longer be allowed in a contractual set-off. And that's been, that's a dramatic change for most employers. The real failure point for the annualised wage agreement will be a failure to conduct mandatory annual reconciliation or exceeding the maximum assumed hours threshold that you used for your calculations when you set your annualised wage arrangement. So, if you're going to move to the annualised wage arrangement, you need to be very clear and accurate on how you arrived at your annualised salary figure and what was included in it. Now, the compliance aspect of it, you must satisfy all award entitlements within each specific pay period if you're going to continue to run on the contractual set-off. The annualised wage arrangement still allows you to go or average over the pay an average over the 12-month period, but you must satisfy the annual safety net and pay for any additional hours beyond the maximum threshold that you use to calculate that annualised wage figure. So what actions are needed? If you're going to continue to rely on the contractual set-off, you need to perhaps restrict the clause operation to the current pay period only. Now, that's based on the law as it currently stands. If the appeal goes ahead and it's successful, you know, we may well be moving back to the older type clause, or it may be something different. So it will be very much a watch this space situation. You know, the appeal might mean that something changes again in 6 months or 8 months' time. But at the moment, the court has been very clear that the wording for the contractual set-off clause to be upheld, it needs to be limited to the specific pay period. For the annualised wage arrangements, the actions needed is to implement continuous tracking and mandatory annual reconciliation that's accurate. So again, that's a fairly dramatic change from where we would have been in the past with just the contractual set-off clause. Can I just jump to the next one, please, EJ? So what are the actions required? If you're shifting from annual to pay period compliance, you're going to have real-time system alerts to ensure that the salary instalments meet the accrued entitlements for that specific pay period. So essentially, it's almost running two different payroll systems, isn't it? It's, hey, here's what I've got for my annual salary, but what I'm really looking now from payroll is, well, what are the award entitlements for the hours that they would have worked, and is there a shortfall? It's a big change. Again, there's the invalidation of pooling. I'd probably suggest you urgently review and amend all your set-off clauses and to remove any language suggesting extended reconciliation. And the reason I suggest that is to stop your payroll team from doing it, or to stop, you know, to reinforce the fact that that's not going to be there anymore. If you put your head in the sand, it doesn't mean it goes away. It just means the problem's going to get worse. So I'd probably address it head on now. And finally, the other big change that you really need to look at is that the court wants rigorous record keeping. So simply relying upon rosters or approved hours is not enough. You need accurate timekeeping. So it might be that you need people to accurately enter or send an email or send a sheet or sign off on what the hours that they actually worked. And that's for all award covered salary staff, regardless of their seniority. And that's to avoid the reversal of the onus of proof or findings that you can't accurately show the hours that your staff worked. It feels a little bit like we're going back to the 80s, doesn't it, with timesheets, but that's essentially what the court is saying. So essentially, here's my call to action to you. You need to immediately review and amend your employment contracts with set-off clauses. That doesn't necessarily mean that next week you're rolling out new contracts, but you do need to say, okay, what's the impact? Which way are you going to go? Are you going to go with annualised wage agreements or arrangements? If so, you're going to need to modify and have a new agreement put in place that shows that you've got that compliance with the awards requirements and that you've got a written annualised wage agreement in place. If you're going to continue on using the contractual offset clause, you need to amend your contracts and reissue your contracts, but you also need to then identify how you're going to mitigate the risk of underpayment during those peak periods. You're going to need to look at investing in technology to enforce mandatory time tracking for all covered salaried staff. So that time tracking component, sure, you could rely upon a paper timesheets and sign off, but for larger employers, that's going to be incredibly cumbersome. But you're going to need to look at, well, if the rosters or the clock in, clock out data is not enough, what technology can I put in place to satisfy the court? Now, the decision's new. We haven't had further judgments on that point. I'm pretty sure people like Employment Hero, Xero, or your major rostering programs are probably working on it as we speak. I don't expect to have all the answers, but it's something there that you might need to sit down and say, do we do a stopgap until our rostering system comes up or our timekeeping systems come up with those changes? The other thing too is that we also want to have agreement from the employee that they're the hours that they actually work. So you want to have some sort of confirmation process. So either a signed acknowledgement or perhaps an email reply, here are my hours, or here's what we understand your hours. Could you please confirm this is correct by, respond email or something like that in the interim. And then finally, the other thing that is really important at the moment would be to schedule a comprehensive and legally rigorous audit against the pay period standards. So perhaps it's about going and identifying those peak periods and saying, well, what are the consequences for me or for my organisation? And if you've got a severe issue, then saying, okay, well, we possibly have an underpayment risk in these months moving forward based on the law as it currently stands. Or it might not be quite as extreme. It might be it's a couple of $100 and only a few staff. If that's the case, then what do I do about rectifying that underpayment? And how do I ensure that it doesn't continue to occur and compound? So how do, going back and making those changes to ensure it doesn't continue to occur. Can I flick forward again, EJ? Oh, questions. Feel free. Sorry, I haven't had the chat open. I'll just pull that up now. If you've got any questions, feel free to put it in the chat and I can have a bit of a crack at it. Otherwise, please do not hesitate to pick up the telephone and have a chat to me. I'm always free for a chat. A chat's not going to cost you anything because a lot of people aren't going to obviously want to raise the specifics of their organisations here in a webinar, a public webinar. Just having a read. I haven't got any questions at the moment, but again, if there's something there or I've struck a chord with you and you want to talk a bit further, just please don't hesitate to pick up the phone. Can I flick to the next one, EJ?
Hi, Darren. We actually have a few questions.
Oh, okay. Shoot.
It's in the Q&A section.
I was in chat. Sorry, EJ.
It's okay.
Dale asked the question, I thought you could only apply an annualised salary arrangement if your award or EA allows you to. That's correct. It's only there, you can only do the annualised wage agreement. It's award based. So if your award doesn't allow you to do it, you won't be able to do an annualised wage arrangement. A lot of them, though, do have it, Dale. So whilst your award might not have it, the general retail, I think hospitality, a lot of them do allow for it. They are sort of a standard term. If you go to the Fair Work Ombudsman and the Fair Work Commission, you can have a look, and they actually have a lot of detail there and allow you to get specific information for each individual award, and you'll be able to see whether or not you can do the annualised wage arrangement. But if you can do it, then you need to make sure that you're actually complying strictly with the model terms that are contained in your modern award. Yeah, the statute of limitation period is only 6 years, but you've got to keep your documents for 7, Dale. So they can only sue you back for 6 years, but what they're saying is that there's a 7-year limitation period for keeping the records. So, but yes, they can only sue you for underpayment for 6 years under the Fair Work claim. We operate a weekly pay cycle, but our award EA allows averaging hours over 4 weeks. Are we able to use 4 weeks as the time period to consider offsets, or are we, just going to limit it to the week? I think the key here is how we put it in our employment contracts. Section 323 says we must pay in full at least monthly. If our award has a different time frame, so if the award says we must pay fortnightly, well, then we must pay fortnightly. But if we're paying weekly, but your award is saying it's not averaging hours, Dale, it's the question, it's the pay cycle. So the Fair Work Act says we must pay at least monthly. Unless the award says we must pay fortnightly, if the award says we must pay fortnightly, then we're stuck fortnightly. But if it's silent on the matter, the longest duration we will have is at least monthly under Section 323, Dale. So in your particular case, you're allowed to average the hours over 4 weeks, but if it's silent, if your EA is silent on when pay must be made, I'm not talking about your contract, I'm talking about your EA or your modern award. If it's silent, then you'll default to Section 323, which is at least monthly, and then you will be able, then the discrete pay unit or the discrete pay period will be the 4 weeks. It doesn't matter if you pay it 4 times in that 4 weeks, Dale. Does that make sense? But I would be very clear in my employment contracts now, though, that even if what the pay period is. So if the modern award says we've got to pay fortnightly, well then the contract should really say we're going to, we're paying you fortnightly, and that's the pay period. But if we want to have a longer period, and even if we want to make 4 pays during the week, the issue there will be is that, well, we're going to pay the pay period. The pay period for the purposes of the modern award is 1 month, and we're going to discharge it by 4 separate payments. But you could still extend out, in my view, to 1 month in that situation. But it would very much depend upon what's in your employment contract and how it's now written. So it's a very big change. And I suppose the thing I want to stress here, it's not about averaging of hours anymore. That's only for the purpose of calculating overtime. What here is that the courts are saying we must discharge their minimum award entitlements for that pay period. It doesn't matter what the averaging of hours clause, because Woolies and Coles had an averaging hours clause of 26 weeks in their enterprise agreements. And the court just said that's not good enough. Section 323 requires it to be at least a month. So it's a dramatic change. It's a really big change. And it's going to require some amendment to the way most of our contracts are drafted. I'll go down to Sharon. Is an individual flexibility arrangement different to an annualised wage agreement? Yes, it is. An individual flexibility arrangement is an agreement between an employer and an employee about terms that have been varied in an award. The flexibility clause says what can be subject into an IFA. That could be about hours of work, when spread of hours, those sorts of aspects. An annualised wage agreement is an agreement where the parties agree to pay an annual salary over the 12-month period at equal amounts. But it will say what are the hours and what are the overtime that's covered in that. And if you pay less, or they work more than those hours and we're entitled to more, you then have to make up the difference after you do your yearly wage reconciliation. So they're 2 very different things there, Sharon. So, and it's certainly not, your IFA is not going to amount to a enforceable annualised wage agreement. There's some strict requirements for both of them. You could possibly have both, but if you're going to pay an annual salary using the annualised wage agreement, you're going to need 2 separate documents for that. Could the slides be shared with the attendees? Yes, EJ will send out the slides to everybody at the conclusion of this. And if you've also got any more questions, please, again, send me an email, pick up the phone. I'm always happy to have a chat. Warren, with the wide-ranging ramifications of these decisions, do you think Woolworths or Coles are likely to appeal these decisions? Yes, I do think they will. I think, though, they may try and litigate a little bit further before they lodge their appeals. At the moment, they're facing a really uphill battle. There's further steps to be taken. So what you may find is that they push on with further directions, and then they further agitate points or try and create difficulties with the current reasoning that the court's found in these further litigation, and then armed with those arguments, try and push on to the court. That's kind of what I suspect may well happen. Particularly for Woolworths, it's a massive amount of money they're facing. But I don't think they're going to rush the appeal. because there's so much on the line, they may be thinking very, very carefully, if we do the appeal, it's sort of all or nothing, right? We've got to win. So, you know, you can expect that if they do appeal, it will be hard fought, well considered, and they'll either try and strengthen their position in the next couple of appearances before the court, or they'll go and seek, you know, some very, very detailed advice from, you know, senior counsel of high degree of prominence, and think very, very carefully as to what their strongest arguments are to run that appeal, because there's so much on the line. It's not just on the line for them, it's on the line for most employers, from what, you know, as you can see from today. It's a massive change to the way we've done annualised salaries in this country. So yes, I do expect an appeal, but, you know, when, I don't know. But yeah, I really think that it's one that I don't think Woolworths is going to sit there and say, oh, well, let's just cop it sweet and move on and change the way we're operating. They've got so much risk that they really don't have much to lose by running an appeal, except for the fact that they're creating an even stronger precedent if they can't get anything watered down as a result of that appeal. But I probably think that, yes, they'll probably run an appeal. Can I just move to the next slide, EJ? Oh, upcoming webinars. As you're probably all aware, we have a really large migration here. Our team sits here as well. So on the 26th of November, the migration team are running a webinar about migration, which is about securing skilled construction and infrastructure workers. Particular focus is going to be about visas, but also labour agreement solutions. We have a team of very experienced lawyers, and if you are needing staff and finding it hard to staff, have a good chat to them about what can be done and whether your organisation can secure a labour agreement, which can actually streamline and increase your ability to get people in when you need them. And then on the 28th of November, perhaps moving away from, so the construction and infrastructure industry is more about how to get highly skilled professionals into the country, employer-sponsored and independent and regional pathways that are available. But if you're having difficulty in either of those areas, sign up. You're bound to get insights, and what you're going to get is a practical explanation of how to go about doing things and strengthening and speeding up your ability to get those visas in and approved. So don't hesitate to scan that code, or you know, wait for the slides to come, and you'll get access to it there as well. If you need to reach me, scan this code. It'll come straight through to myself. So don't hesitate to do that. That'll also be on this in the slide sheet. So if you want a free consultation as well, I'm happy to have a chat. It won't come as a cost to you, but I hope you got something out of today. It is an important sort of matter. I don't want you to be alarmed, but I do think we need to go away and say, okay, what do I do about moving forward? Which way do we go? And what are my risks as a result of this decision? And you know, there's a little bit of homework for everybody there to sit down and say, okay, you know, what's my current exposure, if anything? And then what do I do about moving forward? Which way do I go? The annualised wage agreement? Or if I can't do an annualised wage agreement, or I don't want to do an annualised wage agreement, what do I do about my contractual set-off clauses? Next slide, please, EJ. Thank you. Yes, thank you. I know I have gone a little bit over time, but thank you for sticking with me. But it is an important matter. I hope you got something out of that. But please feel free to reach out if there's something you require a bit more clarification about. And I really do appreciate you giving up your lunch hour to spend it listening to me drone on. So thank you.